In this episode, I would like to discuss about one important Latin maxim of the law of torts, that is Damnum sine injuria, or damage without injury. That means if any person suffers some damage by the conduct of any person, then what is the remedy available in accordance with the law of torts, whether he can get the compensation or not. That is the topic of discussion today, that is damnum sine injuria or damnum absque injuria. The Latin maxim damnum sine injuria etymologically or literally means damage without any injury. That means if any person suffers because of the conduct of any person or act of any person from some damage, he will not get any relief unless there is violation or infringement of the legal right. So that means if there is any damage caused to a person by the act of someone else, he will not be relieved or cannot get any compensation or remedy in pursuance of the law of torts unless there is the violation or infringement of the legal right, that is damnum sine injuria or damage without injury or infringement of the legal right. Salmon stated that there are some acts which are though harmful but are not wrongful, and so the person cannot get any relief in these circumstances, and that is why no cause of action or no right to sue will arise if there is any such type of act which are harmful but are not wrongful in strict sense of the term. So that is why damnum sine injuria has one contrary principles, that is ubi jus ibi remedium. In law of torts, it is the common maxim that ubi jus remedium, that means whenever there is a right, there is a remedy, but this is exception in this case of damnum sine injuria. The doctrine of ubi jus remedium is not applied while explaining the damnum sine injuria, because according to ubi jus ibi remedium, if there is any right, there is a remedy, but damnum sine injuria says that damnum means damage, sine means without, injuria injury. So if there is no injury or infringement of the legal right, then only suffering the loss or damage will not give any cause of action. That means no relief can be obtained. So damnum sine injuria, damnum sine or absque injuria, that means damage without injury, means there is no violation of the legal right. Absque means absent or without, and which is contrary means ubi jus ibi remedium, that is the principle or another Latin maxim of the law of torts, that where there is a right, there is a remedy. It has no application in the doctrine of damnum sine injuria. So ubi means where, jus means legal right, ubi means place, idem means the same author or authority, and remedium means remedy. So if there is any violation of the legal right, there must be some remedy. So if there is any right, there is some remedy, but in case of damnum sine injuria, this principle is not applied, because damnum sine injuria says that even if the person has suffered some damage or loss because of the conduct of any person, unless and until there is the infringement of the legal right, it is not actionable. Regarding damnum sine injuria, the first important case I would like to discuss, that is Gloucester Grammar School case, decided in the year 1410, and judge was Y.B. Hillary. Now what happened in this case, that the defendant was the school teacher of Gloucester Grammar School, and because of some personal reason he left the school and he started a new school, and where he fix the school fees for each student, that is very nominal, only 12 pence per quarter per student, and he was very much popular amongst the students. Whereas the plaintiff, that is Gloucester Grammar School, their fees was much high, 40 pence per quarter per student. So that is why many students left out the original school and joined in the defendant school. So ultimately the plaintiff's business hampered because of the act of the defendant. But as per law, if it is the right of the plaintiff to carry on any business, similarly the right to carry on the business has to the defendant. So that is why it was decided by the court that though by the conduct of the defendant teacher there is the monetary loss on the part of the plaintiff school, that is the Gloucester Grammar School, but actually there is no infringement of the legal right. That means damage is caused, but there is no violation of the legal right. So according to the Damnum Sine Injuria, that means if mere damage is caused to a person by the conduct of someone else, but if there is no infringement or violation of the legal right, then it is not actionable. So I can cite some legal provisions from Indian perspective in this regard, which is very much relevant with this Gloucester Grammar School case. That is, by virtue of Article 19 clause 1 G, subclause G, Article 19(1)G says that every citizen of India shall have a right to carry on any profession, occupation, trade or business. So according to the equality of Indian Constitution, every citizen deserves the right to carry on any profession, occupation, trade or business. He cannot be restrained, and moreover it is supported by virtue of section 27 of the Indian Contract Act 1872, which emphasizes that if there is any agreement which restrains any person from carrying on any trade, profession, business, that agreement is void to that extent. So if any agreement is made to restrain any person by virtue of section 27 of the Indian Contract Act, whereby a person is restrained from carrying on his trade, business, profession, that is void ab initio. So that is why what I have stated that Gloucester Grammar School case 1410, Justice Y.B. Hillary, a very landmark judgment in this aspect of Damnum Sine Injuria, and later on it is very much complied with various judgments of Indian court also, later on I will discuss. So it is very old and prominent case in the field of Damnum Sine Injuria. Now I would like to discuss another landmark judgment, that is Chesmore versus Richard, decided in the year 1859 by Lord Wenstell. What happened in this case, that the plaintiff used to enjoy the stream water of river Wandle. Actually it was filled up by the water percolating from the subterranean premises, that means it is percolating through the underground strata of the soil, and thereby he used to run the mill. And what happened, that the defendant was actually the landowner of the adjacent premises, adjoining land, and what happened, that he sank a well which ultimately diminished the water from the main stream, which was actually filled by the subterranean water and percolating through the underground strata. So as the defendant sank the well, which ultimately diminished the water of the stream, and thereby the interest of the plaintiff was jeopardized. His interest hampered because there was lack or shortage of the water, and ultimately he could not run the mill properly. So thereby he filed a case against the defendant, restraining him from sinking the well. But court stated, it was decided by Lord Wenstell, that how the person who is the owner of a plot of land, he can be restrained from using his own premises. If any person is the owner of a plot of land, by virtue of this and by dint of law, he has the right to enjoy not only the upper portion of the soil, he has also deserved the right of subsoil. And so, if he thereby sinks the well and thereby he extracts the water from the subterranean layer, so and thereby diminishing the water from the mainstream, and ultimately the plaintiff's interest is jeopardized. So, no remedy is there, because a person who is the owner of the plot of land, he can exercise his right to enjoy the premises along with the subterranean premises and along with the subsoil rights. So, what happened that as the defendant sank the well, which ultimately diminished the water level of the mainstream and which ultimately hampers the interest of the plaintiff, but no remedy can be given, because it is the damnum sine injuria, because here damage is caused obviously to the plaintiff, but the defendant exercises his right in his own premises. So, no person can be deprived from enjoyment of his right in his own premises. So, who has the right to use the premises? He has also the subsoil right, and so if he abstract the subterranean water and thereby causing the damage to the other person, he cannot be held responsible. So, this doctrine, as I have stated, that Chesmore versus Richards in the year 1859, Lord Wensdale stated, and the concerned river was River Wandle, and the mayor of Bradford versus Pickles, in this case this rule was extended. So, this rule which I have discussed, it was further extended in mayor of Bradford versus Pickles case, because it was decided by the court in this case that even if the defendant has done such act with the malicious motive, if there is the malicious intention, still he cannot be held responsible. So, means the rule given in the earlier judgment, that is the Chesmore versus Richard, it was further extended by dint of this case, mayor of Bradford versus Pickles, by Lord Halsbury. So, Halsbury stated over here that if the defendant has acted this type of interception or interference with the exercise of the right of the plaintiff, he will not be remedied, because no defendant will be responsible, because if he has acted with his own jurisdiction vicinity, because even if he has acted maliciously, still he will not be responsible. Now, I am discussing about this judgment. Now, I would like to discuss about another important judgment regarding this damnum sine injuria, that is mayor of Bradford Corporation versus Pickles, decided in the year 1895, presided by Justice Halsbury and Lord Osborne. What happened in this case, that plaintiff derived the water from the adjoining premises of the defendant, that is Pickles, and the plot of land was a little bit high level, and so the water flowing to the downwards and the used up by the plaintiff. Now, what happened that the defendant Pickles thereby he dug up a shaft, he sank a shaft, and which ultimately diminished the water resource of the plaintiff. So, his using of the water was seriously damaged because of the conduct of the defendant, because the defendant sank a shaft, and so the plaintiff hereby filed an injunction against the defendant, restraining him from digging the shaft or sinking the shaft. But it was observed by the court of law that so far the defendant is exercising his lawful right over his premises, so how he can be restrained? The plea taken by the plaintiff was that the defendant has acted it motivatedly or maliciously. The reason is this, because the plaintiff had not paid to the defendant the exorbitant rate of the price of the plot of land, and so he motivatedly sank the shaft and thereby diminished the water. But it was observed by Lord that so far a person is exercising his lawful right in his own premises, how he can be restrained? And so even if the damage is caused to the plaintiff, but there is no violation of the legal right, there is no legal wrong. So, only mere causing the damage will not remedy the plaintiff if there is no such violation of the lawful right. So, in the instant case, court has took the step further, that is from the Chesmore and Richards case which was decided regarding the Damnum Sine injury. Here court further stated that even if there is the existence of the malicious motive, that the defendant has acted malafidely with malified intention to disturb or intercept the right of the plaintiff, still plaintiff has no remedy so far he is exercising his lawful right over his own premises. So, that is the principle of the Damnum Sine Injuria. That means even if the damage is caused, but there is no violation of the lawful right, so nothing can be done. That is why, though by such activity of the defendant there was the water of the used by the plaintiff was discolored and also it was diminished, but still no remedy is available, and because by virtue of this principle, that is Damnum Sine Injuria. It was further observed by my lord in this case that if the motive is ill, that means if there is the malicious intention, but if the act is not unlawful, then there is no remedy available to the plaintiff. Contrarily, he observed that if the motive is very generous or philanthropic, but if the action is unlawful or wrongful, then also the defendant is not protected. So, if the act of the defendant is ill motive, that means he has acted something with ill motive, but there is no such legal wrong, then he is protected, no remedy is available to the plaintiff. But contrarily, if he has acted with very generous motive or philanthropic motive, but his act is unlawful or there is violation of the legal right of some person, then also he will be prosecuted. That means in that case he will not get any advantage. So, if his purpose is generous or philanthropic, but his act is unlawful, then remedy is available to the plaintiff against the defendant. Now, I am discussing the next judgment, that is Mogul Steamship Company versus MC Gregor Go and Company. Here the plaintiff suffered because of the competition in the trade, because some private traders acted for furtherance of the business interest and private interest, and thereby he was ousted from the market. But court said that he cannot get the relief because other persons has the right to protect their interest of business. So, what happened here, that some traders has acted for furtherance of the private interest and thereby drove the plaintiff company out of the market. So, a group of steamship company combined together, and they ousted the plaintiff company from the tea trading business by offering the reduced freight charges. So, they reduced the freight charges, and in competition the plaintiff company drove off from the market of tea trading business. Now, it was decided by the court that though there may be some application of unfair means by the traders for furtherance of the private interest, but still he cannot get any relief, though there is the damage caused, but there is no violation of the legal right, because there is no legal wrong on the part of the defendant, because they acted to extend their business, to protect their business and to increase the profit, and that is the exercise of the lawful right of the trader. Though there is the exercise or some adoption of the means of unfairness, but still the action, it is not actionable by the plaintiff, because though there is some damage, but there is no violation of the legal right. So, let us have a look that Mogul Steamship Company versus MC Gregor Go and Company, decided in the year 1892. the brief, as I have already stated, that here also the application of the principles of Damnum Sine Injuria. Now I am discussing the Indian perspective relating to the principles of Damnum Sine Injuria and its application. So I am first citing one landmark judgment, that is Anand Singh versus Ramchandra, decided in the year 1963, AIR, reported in AIR of Madhya Pradesh High Court judgment. What happened in this case, that plaintiff filed a suit against the defendant for demolition of the two walls constructed by the defendant. So defendant in this case constructed two walls, and as a result the water in between the plaintiff's house and defendant's house, which was passing through a lane, actually by force it hampered, it caused damage to the plaintiff's wall. So the lane actually belonged to the defendant, and the water was passing through that lane, and ultimately by the construction of that two walls by the defendant, plaintiff's wall got damaged. Now he filed the suit for demolition of the wall, and the trial court gave the decision of the demolition, and further the trial court observed that defendant is to repair the damaged portion of the wall 1 yard from the bottom by plastering it, and moreover he is to pave the entire lane by the slab. So in appeal also, further in appellate court, in first appeal, the order given by the trial court was upheld. So that is why this second appeal originated. So Justice H. Khan observed in the second appeal that the observation made by the trial court and the first appellate court was vexatious, it was wrong, because here the defendant has not acted in a wrongful manner. He has erected the wall in his own premises, which every person who has any ordinary right to exercise in respect of his plot of land. So though any damage is caused because of his act, because since the water is coming from the side of the wall of the defendant towards the side of the wall belonging to the plaintiff, but there is the damage, but there is no violation of the legal right. So Damnum Sine Injuria principle is applied there. So actually court followed the Gloucester Grammatical School case. That means damage is there, damage sustained, but there is no violation of the legal right. If any person is the owner of any plot of land, he has the full exercise to erect anything upon his soil, he can enjoy everything upon this in respect of the plot of land. So the court said that this is the principles of Damnum Sine Injuria. So the order given by the trial court and the first appellate court was set aside. So that is the judgment, means Anand Singh versus Ramchandra, AIR 1963, Madhya Pradesh, Justice A.H. Khan. And later on in another judgment, that is Jasbhai Motivbhai Desai versus Roshan Kumar Haji Basir Ahmed. In this case also it was the principle of Damnum Sine Injuria was followed. Now I would like to discuss about this decision. So the next case, as I have stated over here, that Jasbhai Motivbhai Desai versus Roshan Kumar Haji Basir Ahmed, AIR 1976, Supreme Court, Justice Sarkaria and Justice Ranjit Singh. What happened here, that petitioner here was the owner of a cinema hall in the small town, that is Mehmadabad, and the respondent concerned wanted to construct another cinema hall in the same premises. Now contention of the petitioner was this, that since the Mehmadabad city is very small, only belonging to means only 15,000 population, so only one cinema hall is sufficient for that small town. So if there is setup of any rival cinema hall which the respondent is going to construct, so that will hamper his interest of business. That means it will adversely affect his monopolistic commercial interest and thereby causing the pecuniary loss because of the competition. But court observed that yes, though by competition his interest can be jeopardized, but that is not unlawful. If he has a right to commence any business, same business can be carried on by other persons, because that is our constitutional principle. Article 19(1)(g) also prescribes that any person can carry on any business as per his choice. So, though it may hamper his interest, but still it is not violation or infringement of any legal right. So, here also the principle of damnum sine injuria that was observed in Gloucester grammatical school case and some other judgment as I have discussed earlier. So, court also followed the same principle that yes, there is the undoubtedly damage is caused, but there is no infringement of the legal right. So, the petitioner cannot have any remedy. So, this is the principle of damnum sine injuria. I have already discussed from various foreign judgments, also little bit few judgments of Indian perspective. So, that means damnum sine injuria means damage though caused, there is no relief if there is no violation of the legal right.